Yeah, so we can start. So today I want us to start looking at a very new topic. So of course I've already shared the notes. So what you will do, don't wait for me to dictate. You just be taking short notes as we move on. Because I've already shared the notes. So as we start looking at topic number 3, it is known as membership. Topic number 3, it is known as membership in a company. It is known as membership. The topic is actually known as membership. The topic is known as membership. That is topic number 3. Under this topic, what are we going to learn? What are we going to learn under this topic? We'll understand from this topic who is a member of a company. Who is a member of a company? Who is a member of a company? We'll understand who is a member of a company. Number 2, what you're going to gather from this topic, the aspect of membership versus shareholder. The aspect of membership versus shareholder. The aspect of membership versus shareholder. Also, what you're going to gather from this topic, it is how does one become a member of a company? How to become a member of a company. How to become a member of a company. How to become a member of a company. Apart from that, of course, now there is cessation. How does one cease to be a member of the company? Cessation of membership. Cessation of membership in a company. So of course, there's a way how you become. But now, how does one end up having to cease from being a member of the company? So cessation of membership in a company. Then apart from cessation of membership in a company, we look at what we refer to as membership rights. Membership rights. Membership rights. We're going to look at membership rights. We're going to look at a key register. Of course, we just mentioned it briefly. But now we're going to look at what we refer to as a register of members. A register of members. A register of members. Then also we look at a very famous case law that is actually under this particular topic. It is known as the majority rule. There's a very famous case law also in this topic. It's known as the majority rule. Sometimes we call it the rule in force versus habitual. Rule in force versus habitual. We call it the rule in force versus habitual. Then we look at something we refer to as representative action. Representative action. Representative action. Then there's the last bit, which will actually be derivative action. Derivative action. There's the last bit, which is actually derivative action. So that's what you're going to learn in this topic of membership in a company. Membership in a company. Membership in a company. So who is a member of a company? Who is a member of a company? That would be the question. Who is actually a member of the company? Who is a member of the company? A member of the company is a person whose name appears in what we refer to as the register of members, which I've already been able to indicate here. So in any case, a person's name is having to appear in this document. Then we'll refer to that person as having to be a member of the company. So a person whose name appears in that register. So a person whose name appears in the register of members. A person whose name appears in the register of members. So we'll refer to this person as a member of the company. A person whose name appears in the register of members, will refer to this person as a member of the company. So when you talk about a register of members, then this is just like a document that is actually found there in the company, and listing as to how who are the members of the company. Who are the members of the company? And of course, as we progress with the topic, you'll end up having to realize that in a company, when you talk about a person having to be a shareholder, ideally, we're having to refer to that person having to be a member. Because when you look at the ways as to how one becomes a member of the company, majority, not if all, it is through having to acquire shares in the company. So eventually, once you become a shareholder in the company, then you'll become the member of the company. Then eventually, your name will be included in the register of members. So in short, this term membership in a company and shareholder in a company can be used interchangeably to mean one and the same thing. Ideally, if a person is actually a shareholder in a company, we are having to say that person is the member of the company. So in other words, you can be able to say a member of the company is a shareholder in the company. The two terms can be used interchangeably to mean one and the same. One and the same. And I'm having to say, when you start having to look at the ways as to how one becomes a member of the company, majority, if not all, these ways, you realize one is going to become a shareholder in the company. Then eventually, he'll become a member of the company. Eventually, his name will be included in the register of members. Who is a member of the company? A person whose name appears in the register of members. This register of members will enlist as to all those who are members of the company. In other words, if you haven't comprehended, we're having to say the term membership and shareholder can be used interchangeably to simply mean one and the same. Because ideally, when one becomes a shareholder in the company, his name will be included in this register. And therefore, eventually, he'll be referred to being a member of that company. Being a member of that company. Being a member of that company. So these two terms can be used interchangeably to mean what? One and the same. One and the same, one and the same, one and the same. And so long as now your name is having to appear in the register of members, then eventually we'll be able to conclude that you are a member of that company. You are a member of that company. So there's something I've been able to mention here, that the two terms can actually end up having to be used what? Interchangeably to mean one and the same. Because you're having to say eventually once you acquire shares and you become a shareholder, you are on the route of having to be included in the register of members. And now we'll be able to conclude that you are the member of the company. You are the member of the company. But take note of what I'm going to say here. Of course, these two terms can be used interchangeably. But you might find there are few exceptional circumstances where one will just end up having to be a member and is not what? A shareholder. Because I'm having to say that a member is when your name will appear here. And majority of the ways, if not all, is through having to acquire shares in the company. So if you acquire shares in the company, eventually you become what? A member of that company. So these two terms can be used sometimes interchangeably to mean one and the same. Because eventually once you acquire shares, you become the member of that company. But you're having to say there are a few exceptional circumstances. Exceptional circumstances where one will just be what? A member. There are a few exceptional circumstances where one will just be a member and is not actually what? A shareholder in the company, or vice versa. He's just a shareholder and is not what? A member of the company. So this term I've said here, you must actually be able to remember it. It is only when your name appears what? In the register of members. It's only you can be able to conclude that you are the member of the company. So if you're a shareholder, your name will end up having to do what? Appear there. And therefore, interchangeably, the terms can be used to mean one and the same, because once you become a shareholder, you now become a member and your name will be included here. But there can be a few exceptional circumstances where you'll end up having to realize that one is just a member and is not actually what? A shareholder of the company. What are these a few exceptional circumstances? Number one is in a company that is limited by guarantee. Remember, we learned about a company limited by guarantee. We can have a company limited by shares, and we can have a company limited by guarantee. So in a company limited by guarantee, there are no shares, and therefore there are no shareholders. We just have members. There are no shares, and there are no shareholders. And therefore we just have what? Members who have actually agreed that they can contribute how much towards the assets were if the company is going to be liquidated. So we can have exceptional circumstances where one is just a member of the company and is not a shareholder. Or sometimes one is just a shareholder and is not actually what? A member of the company. We've already mentioned one of those what? Exceptional circumstances in a company limited by guarantee. So in companies limited by guarantee, there are no shares. There are no shares or shareholders. It's a type of a company. There are no shares or shareholders. We've already learned about it. It's a type of a company where we only have what? Members, and we don't have what? Shareholders. In one limited by shares is where we'll have shareholders. And therefore those shareholders will be what? Will be members. But here is one of the exceptional circumstances where those who are the owners of this company are just what? Members. They don't have actually shares. They've just agreed as to how much they can contribute towards the assets were it the company is to be liquidated. And therefore, in a company limited by guarantee, we don't have shareholders. We just have what? Members. And of course, that happens to be what? One of the exceptional circumstances where we only find what? Membership and not actually what? Shareholding. Another exceptional situation or maybe circumstance, number two is under what we refer to as what? Transfer of shares. Transfer of shares. Of course, you learn more about this under transfer of what? Of shares. Transfer of shares. Under transfer of shares. A transfer of shares is an agreement or a contract between two parties to transfer shares amongst themselves. One of the parties there is normally known as the transferor, and the other party is the transferee. What you'll eventually realize that this process of having to undertake transfer of shares, it is a process. It's not a one-day event. It will likely end up having to take what? Quite some time. Even though the two parties would have actually already been able to agree, and of course this one has already paid the consideration, which is the price for the shares, and they have already signed off the agreement. Before these shares are actually eventually transferred by the company to the transferee, the board of directors has to approve. So by the time the board of directors approves, it can be 2 weeks, it can be 3 weeks, it can be a month, it can be 2 months. But of course, you can actually be able to see already these two parties have already agreed. They have already agreed. This one has already paid for the price of the shares to the transferor. But they're just having to await in the company. The board of directors has to do what? Approve. So during this moment, upon which now in this case, that approval has to occur, it means that this party you're having to call what? A transferor would have already lost the shares. Would have already lost the shares to what? To the transferee during that 1 month, because they have already signed the agreement. In fact, this one has already paid for the shares. So he would have already lost what? The shares. He would have already lost the shares. And then it means he won't be a shareholder anymore. But you know what will be happening in the company? His name will still be appearing in the register of members. His name will still be appearing in the register of members. During that 1 month, he has already lost the shares to the transferee because they have already signed the agreement. It's only that the company is yet to approve. Until the company is actually having to approve by the board, is when now they can remove the name of this transferor from the register of members. So ideally what is having to happen here, his name is still having to appear. Just go back to the initial definition I've said about membership. A member of the company is a person whose name appears in the register of members. The transferor here, his name is still having to appear in the register of members, but ideally he has already lost the shares. So he's no longer a shareholder, but he's a member. He's no longer a shareholder, but he's actually a member because his name is appearing in the register of members. Who is a member of the company? A person whose name appears in the register of members. For this transferor, his name is still having to appear in the register of members, but he has already lost the shares. He's no longer what? A shareholder. That is another situation where this party is just a member, but he's not what? A shareholder. And on the other hand, this one is already what? A shareholder, but he's not a member because his name is yet to be included until the board approves the transfer. Is when they'll be able to do what? Effect the transfer, and of course now in this case eventually make changes to the register of members by removing the name of this one and including the name of this one. So in this situation you can be able to see this one is just a member because his name is still appearing. This one is just a shareholder because he has already gotten the shares under the contract or agreement, but he's still having to wait. The company has to approve. I'm just waiting they approve so that they can approve, put my name in the register of members. Then I become what? A member. So in this kind of a situation under transfer of shares, this party here is just a shareholder. It's just in this case what? A member. So it's just actually a member and is not what? A shareholder because he has already lost the shares. While this one is just a shareholder and is not what? A member. Until the board of directors of the company approves, which might take quite some time, is when I, in this case now, will be able to say, now the name of this one has been included in the register of members and therefore he has become what? A member of the company. So that's another what? Situation where you find that one is just a member and is not a shareholder or vice versa. He's just a shareholder, but is yet to become what? A member of the company. Yet to become a member of the company. Another situation, number 3, is under what we refer to as what? Transmission of shares. Transmission of shares. Transmission of shares is almost similar to what? Transfer of shares, but they are not in this case the same. They're not actually in this case the same. Of course, we'll delve deeper into this in our next topic, is actually topic number 4. But this is what you have to take note of in this case regarding transmission of shares. Take note, we have transfer and we have what? Transmission. So don't confuse the two and you end up having to say they are the same. Under transmission, it occurs in a situation where there is death. insanity, or bankruptcy. There is death, insanity, or bankruptcy of a member or a shareholder of the company. In case of death, insanity, or bankruptcy of a member or a shareholder of the company. So, of course, in case of death, these shares have to be transmitted to the beneficiary. Maybe there's a will. There's a will which has not been disputed, because we can see most of these wills are being disputed. There's a will, and he has mentioned what? The beneficiary. Insanity, so you can appoint what? A trustee. Insanity, or those persons who are actually insane, they're incapacitated to undertake certain contracts or agreements. And therefore, part of the areas they might actually be limited is in terms of having to do what? Own shares in the company. So they can agree, in this case, they're having to do what? Transfer to a trustee. A trustee is someone who can be able to hold property on your behalf. In case of bankruptcy, inamaanisha umesota maze, and therefore in this case, creditors are actually all over you. They're actually all over you. And therefore, all your assets are supposed to be taken over by a person we refer to as a receiver who has been appointed by the court. In case you're not actually able to settle your liabilities, you can be declared to be bankrupt by the court or maybe by your creditors. Then what will happen? They'll appoint a party we call what? A receiver, who will eventually take over your assets. Part of the assets to be taken over are the shares. So shares are still what? Assets. So they can be taken over by what? By a receiver. They can actually be taken over by a receiver. So of course, still, this will actually end up having to be a process. This transmission, just the same case as transfer, it is a process. It's not a matter of, in this case, a person having died today, and already the company is aware, and therefore they remove his name in the register of members. So they have to get what? Letters of administration from the beneficiaries, having to indicate that this person is no longer with us. Ideally, under his will or his letters of administration, it is that these shares are supposed to be transferred to the beneficiary. But you have to take note, before the company gets this kind of a notice to be informed about the death of a shareholder or a member, his name is still having to appear in the register of members. But under that situation, in this case, already has lost the shares, because they have to go to the beneficiary. He has already lost the shares. A person who has died, will he end up having to wake up, come take over the shares? He won't, but his name will still be appearing in the register of members. So under transmission of shares, ideally, this person is just a member, but he has already lost the shares legally to the beneficiary. Under operation of law, he has already lost the shares to the beneficiary. Once they present the letters of administration under will, then it means the shares will actually be transmitted to the beneficiary under the will. So automatically, by operation of law, once that will is actually presented, then this one eventually becomes the shareholder. But before they actually effect and actually remove the name of this person from the register of members, he's still having to appear just as as a member. But already the shares have actually been lost. That's another situation where you might end up having to find one is just a member in the register of the members, but is not actually a shareholder of the company, because automatically, by operation of law, he has already lost the shares. When you talk about bankruptcy, a party has already actually been declared to be bankrupt. So it means in this case, there has to be evidence to be produced upon the company having to indicate that party has actually been declared to be bankrupt, and the shares or the assets are supposed to be taken over by the receiver. So before the company actually effects and removes this bankrupt party from the register of members, ideally he's still having to appear as a member of the company. But automatically, by operation of law, the shares have already been lost to the receiver. Once they effect, the board has approved and they have actually effected, is when now they go and actually do remove the name of this bankrupt party from the register of members. But so long as his name is still having to appear in the register of members, he still be concluded to be a member of the company. Go back to my initial statement. Who is a member of the company? A member of the company is a person whose name appears in the register of members. Go back to my initial statement. Who is a member of the company? A member of the company is a person whose name appears in the register of members. In this case, you're having to say this party, the dead person, the name is still having to appear there, but he has already lost the shares. So you can see there's still membership, but of course the shareholding has already been lost. So that's another situation, or maybe what a circumstance whereby you might end up having to realize that one is just a member of the company, and in this case is not actually what a shareholder, or vice versa. Like you can see the parties at the receiving end, they're just shareholders, but their names are yet to be included in what? In the register of members. But under any other circumstance beyond these ones you've mentioned here, it means the two terms can be used what? Interchangeably to mean one and the same, because eventually, once you become a shareholder, then your name is normally included in the register of members. But you can just have a few exceptional circumstances where you might find yourself, you're just a shareholder, but you're yet to become a member. Or maybe you are a member, but in this case, you've already lost what? Your shares. You've already lost your shares. You've already lost what? Your shares. So those are some of what the exceptional circumstances under which you might actually find that one is just a member and is not a shareholder, or is a shareholder and is not what? A member. But of course, generally, the two terms can be used interchangeably to just mean one and the same. Membership or shareholding is just one and the same, except for those a few exceptional circumstances we've ended up having to mention. We've ended up having to mention. So you have to take note of that. Take note of that. When bankrupt as a person, are you not different from the company? Why are you affected? A separate legal entity. Why are you affected? A separate legal entity. So when bankrupt as a person, are you not different from the company? So you see, if you have shares in a company, those are part of the assets you're having to own. What thing you have to take note about in this case being declared to be bankrupt, or a receiver having to be appointed. In case of an individual, that receiver normally takes over your assets. So if you have shares in a company, those are part of what? Your assets. So when a party is declared to be bankrupt, it means in this case, you are owning shares in the company. You are owning assets in the company. So apart from, in this case, those shares, you could be having land at home, you could be having a motor vehicle. So they'll take over the motor vehicle, they'll take over the land, they'll take over the shares, they take over your assets. Shares are assets. If you own shares in a company, they're like assets. Intangible assets. That's why they'll be taken over. That is why they'll be taken over. So we can look at ways how one becomes a member of the company. So ways how one becomes a member of the company. And of course, I've already been able to mention majority of these ways. You realize that it is through having to acquire shares in the company. Ways one becomes what? A member of the company. Ways to become a member of the company. Ways to become a member of the company. Become a member of the company. And there are a number of ways as to how you can be able to become a member of the company. Number one is through direct allotment of shares. Direct allotment of shares. Direct allotment of shares is through direct allotment of shares. Number two is through transfer of shares. Transfer, I've explained it briefly already. Transfer of shares. Number three is through what we call transmission of shares. I've also explained it briefly already. Transmission of shares. Transmission of shares. Number four, it is subscribing to the memorandum of the company on formation. Subscribing to the memorandum. Subscribing to the memorandum of association. On formation of the company. On formation of the company. Subscribing to the memorandum of association on formation of the company. Number five is through the doctrine of estoppel. Through the doctrine of estoppel. Through the doctrine of estoppel. Doctrine of estoppel. Through the doctrine of estoppel. Then another way is through agreement. So by agreement. So through agreement to become a member. We can talk of through agreement to become a member. So by agreement to become a member. So by agreement. Then number seven, it is taking up qualification shares. Taking up qualification shares. Taking up qualification shares. Is taking up qualification shares. It is taking up qualification shares. Taking up qualification shares. So what do you mean by direct allotment of shares? Is like what this company has done. It is known as what? Kenya Pipeline. Is it the Kenya Pipeline or something? So they can do like a kind of like in this case what an allotment. So they prepare what we call a prospectus, then they invite members of the public to apply for the shares or subscribe for the shares, or invite outsiders to be able to apply or subscribe for the shares. Once they do so, then eventually the shares will likely be allotted. So through a prospectus, the company can invite for subscription or application for its shares. So eventually, once the application have actually been received, then they likely end up having to allot the shares, and eventually those will be allotted, becomes what? Shareholders of the company. Then eventually they'll become what? Members of the company, because I've already been able to tell you that shareholder membership interchangeably used as one and the same. Majority of the ways as to how you become a member of the company is through having to become a shareholder, and therefore eventually, once you are allotted the shares through an IPO or a direct offer by the company, then you will become a shareholder, and eventually you will become a member of the company. Transfer of shares, this one I've already explained. There are two parties. The transfer of shares is a contract or agreement between two parties, the transferor and the transferee. The transferor is the one who actually agrees to transfer the shares to another party, known as the transferee. So the consideration for the transferor is to give out the shares. The consideration for the transferee, the one receiving, is to pay for the price of the shares. Once they have entered into this kind of an agreement, then in this case it means the transferor, now the person who becomes the shareholder here is the transferor. The transferor will become a shareholder and eventually become a member of the company. While the transferee will lose what? Membership. While the transferee will lose membership, the transferee will lose membership, the transferee will lose membership. Transmission, I've also explained briefly. This one occurs in case of death, insanity, or bankruptcy of a member or a shareholder. So in case of death, it means the shares will be taken over by the beneficiary. In case of receivership or maybe bankruptcy, it means in this case, the shares will be taken over by a person we call a receiver. So we'll learn more about a receivership in topic number 15. Receiver, it will be taken over by a receiver when you are declared to be bankrupt. Bankrupt simply means in this case, you cannot actually be able to meet your obligations as and when they actually fall due. And therefore, creditors are actually all over you. And if in this case, you had actually agreed in the letter of having to lend the money, it means they can take the action to go to the court, then the court will declare to be bankrupt. And therefore, they likely end up having to appoint a receiver to take over part of your assets. Amongst them, having to be what? Shares in a company. And therefore, eventually, that receiver becomes the member of the company. That beneficiary becomes the member of the company. That trustee, under insanity, becomes the member of the company, because now they will take over the shares. So that's what we mean by transmission of shares. Transmission of shares. Then subscribing to the memorandum of association on the formation of what? Of the company. We've been able to see for like companies limited by guarantee, you don't acquire shares. But of course, you subscribe and actually agree to the memorandum on the formation of the company that you can actually contribute a certain amount of money towards what? The liquidation of the company. So if you're having to subscribe on formation of the company to the memorandum, to be one of the members of the company, like in a company limited by guarantee, then it means you likely eventually become what? The member of the company. So by subscribing or signing off or having to agree, you're going to be amongst the members of the company. Even without having to do what? Take over shares, it means eventually you become what? A member of the company, because you've been able to say for companies limited by guarantee, they don't have these things of shares. But of course, they have members. These are the ones who have subscribed to the memorandum on formation. They have actually agreed. In any case, the company is liquidated. This is how much you can be able to contribute to the assets, were it the company is to be liquidated. So by subscribing to what? To the memorandum of association. Then this one, through the doctrine of estoppel. What does the doctrine of estoppel simply mean? Sometimes your name might actually end up having to appear in the register of members by mistake. By mistake. Sometimes your name might actually end up having to appear in the register of members by mistake. So if it happens during this time upon which your name is appearing by mistake, you enjoyed membership rights. You enjoyed membership rights. We're just going to look at membership rights in a few. You enjoyed what we call membership rights. Membership rights is, for example, you ended up having to vote at the meetings of the company. You received dividends. You received what? Dividends. You've actually been sent minutes of meetings. You've actually ended up having to get what? Notices of meetings. You've actually participated actively on matters pertaining to membership rights. So during this time, your name is appearing by mistake. You can't deny the fact that you are not what? A member of the company. So if that is what has occurred, maybe for over a particular period of time, during this period, we can be able to conclude that indeed you are still a member of the company through what? The doctrine of estoppel. So even though your name is appearing by mistake, during this particular point in time, your name is appearing by mistake, the point is, this is where the meat of the point is, you have enjoyed membership rights. You have enjoyed membership rights. You've been coming to meetings and making a lot of noises. Yet your name is just appearing there by mistake. Maybe it was the mistake of the company. Then something happens. Maybe in this case, you are part of those who are approved. You are on the list of those who are approved as that resolution. So you cannot actually come on later on and actually claim, in fact, my name was appearing here by mistake. I'm not a member of this company. Untaka kuruka kipetero. So in that case, it cannot actually end up having to happen. What it will end up having to be argued is that even though your name was appearing by mistake, through the doctrine of estoppel, you enjoyed membership rights during that period, and therefore it can be concluded you are just what? A member of the company. So it is when your name is appearing by mistake, and during that particular point in time, you've enjoyed what? Membership rights. You can't deny the fact that you are actually what? A member of the company. A member of the company. Then through agreement, by agreement, this one majorly happens, for example, in private companies. So if it happens, I want to become a member of a private company. So we can actually end up having to agree with those who are already what? Members there. So they'll end up having to transfer some shares to me. And of course, now in this case, we'll do the necessary facilitations for the shares to be transferred into my name through the register of companies. Through the register of companies. So we'll in this case sign off what we refer to as what? A share transfer instrument. So of course, we learn about transfer of shares in our next topic. So in a private company, through an agreement, we can be able to agree to add on or add more members into the company. So they'll be able to take over part of the shares that we do have in the company and eventually become what? Members of our company. Members of our company. Then number seven, taking up qualification what? Shares. Taking up qualification shares. What do you mean by taking up qualification shares? It is that eventually one day, of course, it is going to happen when Lena will actually eventually become a director at Safaricom. Lena will likely be called upon to take up some shares at Safaricom. He won't just be a director. Financial prudence requires that eventually when you become a director, at least you should become a part owner of the company so that you can be able to make decisions prudently. So in that case, Lena, you'll likely be called upon, you take up some shares at Safaricom. Eventually, when you take up the shares, you are a director, you've taken up the shares. This kind of shares, we normally call them qualification shares. So as a result of this, Lena, you'll eventually become a shareholder and a member at Safaricom. Eventually, when it happens, you'll become a shareholder and a member at Safaricom. What are qualification shares? Shares taken up by directors once they have actually been appointed to become directors of what? Of the company. Eventually, they become shareholders and eventually they become members of the company. Qualification shares. Qualification shares. We call them qualification shares. Financial prudence requires that you become a part owner as a director so that you can be able to make prudent decisions because you're having to manage the company on behalf of the shareholders or the members. When you take up those kind of shares, we call them qualification shares. This one is normally provided for in the articles of the company. It is normally provided for in the articles of the company, but eventually once you become a director there, you can take up some shares. So those are the ways as to how one will actually eventually become what? A member of the company. Now that you've already looked at ways to become a member, we are far much better off if you just in this case do what? Very quickly look at ways of cessation. Before we look at anything else, let's look at ways of cessation. Ways of cessation. Let us look at ways of cessation of membership. We've just seen how one eventually becomes a member. And of course, this area of how one becomes a member, it is very common in the exam. You have to be very keen. Learner, you have to be very keen. So cessation of membership. Cessation of membership. Cessation of membership. How does one cease or end up not having to be a member of the company? So there are two that you've already been able to mention. Who's going to give us those ones? There are two that you've already been able to mention. Who's going to give us those ones? Evans. There are two that you've already mentioned. Which ones are these? Which ones have you already been able to mention? Transfer So we have transfer, so you're mentioning them, so they are there. So they are there. So we have in this case what? Transfer. Transfer we mentioned, because under transfer there are two parties, the transferor and the transferee. The transferor is losing because he's selling. Selling, exactly selling, exactly losing. So while the transferee is receiving. So under transfer, this transferor is actually losing. So transfer of shares. Then when you go to the other one, transmission, you can break them down. You can talk about it. Just break them down. So this is how we make marks in exam. So this is how we make marks in exam, bankruptcy. So don't write it as one. Don't write it as one. Ever will be reducing your marks. You have to be very smart in this exam. You have to be very strategic. So you break that one so that you make more marks. So in case of death, bankruptcy, insanity, insanity. Of course, if you look at your notes, they are there. So number 5, we have mortgaging of shares. Mortgaging of shares. Mortgaging of shares. We have mortgaging of shares. We have which other one? So lien on shares. Lien on shares. We have liquidation of the company. Liquidation of the company. Liquidation of the company. Liquidation of the company. Which other have we not been able to mention? So you have lien on shares, liquidation of the company, transfer of shares, death, bankruptcy, insanity, mortgaging of shares. Which other have we not actually been able to mention? The others we haven't actually been able to mention. Which other have we not actually been able to mention? And see, people have already listed them there. Valid surrender. Yeah, valid surrender is correct. Valid surrender is correct. Valid surrender of shares. Just validly surrender the shares. Apart from valid surrender, liquidation. Forfeiture is correct. Forfeiture is correct. I can see forfeiture. Forfeiture is correct. Forfeiture of shares. Forfeiture of shares. Then there's conversion of a share warrant. Conversion of what? A share certificate into a share warrant. Conversion of share certificate into share warrants. So conversion of share certificates into share warrants. Into share warrants. Conversion of share certificates into share warrants. So transfer of shares I've already explained. Do I really have to explain again? Do I really have to explain again, Mercy? Do I really have to explain again, Mercy? Do I really have to explain again, Mercy? I have already explained. Here there are two parties. There is the transferor. There is the transferor. And there's of course what? The transferee. The transferee. There are these two parties. There's the transferor and the transferee. The transferor is the one losing the shares because he's the one agreeing to transfer to the other party. And therefore, as a result of that, he seizes. While on the other hand, this is the one now who appeared under becoming. The transferee is receiving. The transferee is receiving because he's taking over what? The shares. And therefore, that's what you're having to say. This one appears in both of them. So because for the transferor is seizing, the transferee is receiving. And therefore, he's becoming. So death, I've already explained. This one I've already explained. In case of death, the shares are normally taken over by the beneficiary. So the beneficiary becomes, while the deceased party loses what? The shares. Then bankruptcy, I've explained. When one is actually declared bankrupt, it means he's not actually able to meet his liabilities and obligations as and when they actually fall due. In that case, a person we call a receiver. A receiver. A receiver is normally appointed by the creditors or by the court to take over the assets of the bankrupt party. Amongst the assets that can be taken over, it is shares in a company. And as a result of that, the bankrupt party ceases to be a member of the company. Insanity, an insane party. This one, sometimes they are incapacitated to undertake certain what? Contracts or maybe agreements. And as a result of this, part of what they can actually end up having to lose is actually membership of the company. And the shares, they can actually bequeath them to a trustee. So they'll enter into a trustee agreement where a trustee will hold these shares on their behalf and manage those shares on their behalf. So we call it, in case of what? Insanity. So mortgaging of shares. What is mortgaging of shares? Mortgaging of shares is where you use your shares as a security for a loan. So of course, you're going to learn more about this one also in our next topic, which is actually shares. Is where you use your shares as a security for a loan. So as you're having to say, shares are assets. So you can utilize what you refer to as your share certificate. You deposit with a lender, maybe a SACCO or maybe a bank if they allow. then in this case, they'll take over your shares. So here what it means, there are two parties here under mortgaging of shares. Is an agreement or a contract where we have the mortgager, and we have the mortgagee. We have the mortgager and the mortgagee. Among the two parties, who is the lender? Among the two parties, who is the lender? Who can tell us who is the lender among the two parties? Between the mortgager and the mortgagee. Who is the lender? Among the two parties, who is the lender? I can see mortgager. Among the two parties, who is the lender? Mortgager. I was asking that because I wanted you to get the point and it has to stick. The lender is the mortgagee. I wanted you to get that point and it should stick from now. It should stick from now. I wanted you to get it so that it can stick from now. The lender is the mortgagee, while the borrower is the mortgager. I wanted it to stick. Now it has stuck. You'll never forget. The mortgagee is the lender. The mortgager is the borrower. The mortgager is the borrower. So in this case, what happens, if you use your shares as a security, it means the mortgagee will take over the shares. Until maybe, it depends with the kind of agreement. He can take over the shares immediately, or he can take over the shares when you have defaulted. So if that is the case, it means the mortgager, who is the borrower, will eventually lose the shares, will eventually lose membership of the company. That's why mortgaging of shares is one of the ways as to how one could end up having to cease to be a member. It is where a shareholder has utilized his shares as a security for a loan. He has mortgaged the shares as a security for a loan. And maybe he defaults. If he actually ends up having to default, the lender, who is the mortgagee, can take over the shares, and eventually it means the mortgager, the borrower, the shareholder will lose membership of the company. Will likely lose membership of the company. He will lose membership of the company. So that's what happens under mortgaging. Then you have lien on shares. We have what? Lien on shares. When you talk about lien on shares, we have this friend of ours known as Benedict. There's this friend of ours known as what? Benedict. Benedict is a very aggressive person. This Benedict operates one of the best restaurants. So this Benedict is a very aggressive person. Benedict operates one of the very best restaurants. You can call them restaurants, and where people actually go to relax. It can be restaurants and bars and restaurants. It is where? In Nairobi City. Nairobi City, not county. Nairobi City. You need to call it a city. Nairobi City County. So don't just call it Nairobi. Call it Nairobi City County. She's a very aggressive lady. At the same time, in this case, she owns what? Shares at what? EABL. East African Breweries Limited. East African Breweries Limited. So very serious shareholder there. Don't joke with this Benedict. The kind of shares she's having to own there is close to 20 million worth. Don't joke. 20 million worth. And at the same time, she's running one of the best chain of restaurants and bars in Nairobi City. You can just imagine how she's having to thrive. So you can see she's actually what? A shareholder here. She's actually a shareholder here. So what happens is that this EAPL, they do supply her. So some drinks, they do supply her some drinks on credits. So for her, what it happens, she takes goods worth 2 million. So every weekend, and she's able to pay. Every week she's able to pay, or at the end of the month, she's able to pay. So then it becomes what? She's connected to this company in two ways. She's a shareholder. At the same time, she's a customer. You can see she's a customer on credit. Customer on credit. She's a customer on credit. She's a customer on the credit on one end. At the same time, she's also what? A shareholder there. Serious one. 20 million worth. 20 million worth of what? Of shares. So when you talk about lien on shares occurs in a situation where the articles of association of this EABL as a company, the articles of association provide that in any case, you are indebted to the company. You are having to owe the company as a shareholder. What can happen is they can actually eventually take over what? Your shares. They can eventually take over your shares. When they do that, we say they are exercising the rights of lien on your shares. So it happens, COVID-19 has just hit, and this business of Benedict is not having to really thrive. So she's not able to service the suppliers. She's having to get from what? From EABL. And the articles are having to provide that in this case, if it happens, you are indebted to the company, you are owing the company, then we'll take over the shares. COVID-19 has just hit. Imagine they have shut down the business for almost 4 months. Nothing's happened. Will she be able to service? Even if in this case it means getting from the pocket. Will she continue getting from the pocket for all those months? It cannot happen. So it means this EABL will be claiming from her some supplies that they had actually made, but she's yet to pay. She'll likely be indebted. She'll likely be owing. The point is, this is where the meat of the point is, the articles of association of EABL provide that in any case, you are a shareholder like Benedict and you are indebted to the company. You owe the company. They can take over your shares. They can take over your shares and maybe dispose them to another party. They recover their money that you're having to owe them. So if in this case it happens, EABL exercises that during this COVID-19 period, it means they would have exercised what we call what? Right of lien on shares of Benedict. And as a result of this, Benedict will no longer be a shareholder at EABL. She'll cease to be a member. What is right of lien, or in this case, lien on shares, is a right provided for to the company under the articles where they are allowed to take over the shares of any shareholder who's actually indebted or actually in this case having to owe any amount to the company. When this right is actually exercised at the appropriate time, it means that person who was actually a shareholder will lose membership of the company. Will lose membership of the company. So that's what we refer to as what? Lien on share. So of course, we're going to look at it again in topic 4. We'll delve deeper into it in topic 4. In topic 4, and now we'll see how it is connected to this one. How it is connected to mortgaging of shares. Sometimes they can occur at the same time. So we'll see in topic 4 when they occur at the same time. Benedict had taken a loan. He had taken a loan from what? From maybe in this case what? From KCB. And she has given the same shares of EABL. She has given them as a security. At the same time, she's owing EABL. EABL is allowed to exercise the right of lien. The bank KCB can take over the shares under mortgages. What happens? They have happened at the same time. She's owing EABL. She's having to owe KCB. So under KCB is mortgage. She mortgaged the shares. Under EABL, they can exercise the right of lien. So sometimes they can occur at the same time. So we'll see if they happen to occur at the same time, what will happen to these shares of Benedict? Who will have the right to enjoy the shares before the other party? Will it be EABL exercising these rights? Or will it be the bank taking over the shares? So we'll be able to see that in topic number 4. Then this the next one. This one is self-explanatory. Learner. This one do I really have to explain? You cannot be a shareholder in a non-existent company. So can you continue to be a shareholder in a company that has actually been liquidated? When you talk about liquidation, it is the process of having to end the life of a company. We say that a company is not born naturally. We have to undertake a process we call what? Incorporation, formation, or promotion for it to come into existence. The same case, we say that a company doesn't die a natural death. A process has to be undertaken to end the life of a company. We call it liquidation. Therefore, later when you hear about the term liquidation, it is that process undertaken to end the life of a company as an artificial person or as a separate legal entity. Once that has happened, it means all who are members cease to be members of the company. Can you really be a member in a non-existent company? It cannot happen. And therefore, liquidation of the company is one of the ways that in this case, eventually, once it is concluded, you will no longer be a member of that company. Valid surrender. Sometimes you can just validly surrender your shares. You can just validly surrender your shares. So maybe in this case, you do not actually wish or continue to be a member of the company. So through valid of surrender of shares, it means one ceases or loses membership of the company. Forfeiture of shares is cancellation of shares of a shareholder who hasn't paid calls on shares. Who hasn't paid calls on shares? So you people, you have done a lot of financial accounting. You have done a lot of financial accounting. You have done a lot of financial accounting, although there are some who haven't been in class for the last 10 years. So they have just appeared in intermediate work. So in fact, in this case, if you ask them what is debit, what is credit, they start asking you, only what are you saying? You are confusing us. But now, if you've done financial accounting, you must have done in this case what? Allotment of shares. Allotment of shares. Allotment, we must have done this one, allotment of shares. An allotment of shares, you are going to be told something like in this case what? First call, second call, then maybe final call. Then maybe you'll be told on allotment. You'll be told on allotment. Maybe the face value of the shares, having to be issued is maybe 20 each per share. Then you are told on allotment they paid 10. On first call they paid maybe 4 shillings. On second call 4 shillings. On final call 2 shillings. So that eventually they can actually fully be able to pay what? The full face value. So forfeiture will happen in a situation where the company has made a call to a shareholder or to the shareholders to pay any, these amounts are outstanding. They are outstanding because it means on allotment, they are calling upon you, make sure you've already paid 10 shillings. When they just allot the shares like this, you must have already paid 10 shillings on those shares that you're having to be allotted. Then they'll say maybe after 3 months, they'll do what? The first call. After another 3 months, the second call. After another 3 months, the final call. Maybe after now, full 9 months, they would have already been able to recover the full face value of what? Of the share. So when you talk about forfeiture, it happens where the company has made a call, has given out a notice to the shareholders to pay any outstanding amount on their shares. Then you fail to pay. They have said you must actually end up having to pay on 1st of April. Part of what? April. Wewe na ujinga wako unaanza kusema 1st of April is Fool's Day, so there's nothing like that, you're not going to pay, it is Fool's Day. So in this case, if you don't actually end up having to pay, then it goes up to 2nd. The company will have the right to, in this case, do what? Cancel or forfeit what? Your shares. But there's a procedure that is normally followed before this one happens. So we look at it in the next topic, which is actually shares. So for forfeiture of shares is cancellation of shares of a shareholder as a result of non-payment of calls. When the company makes a call, you make payment of any outstanding amount on your shares. Then the articles of that company are having to allow, they can cancel out your shares and you lose your shares and you lose membership of the company. So that's what you mean by forfeiture. Cancellation of shares of a member of the company as a result of non-payment of calls. What is a call? A notice to the shareholder to pay any outstanding amount on his or her shares. If it happens you fail to make payment of that call on that date indicated on that notice on that call, it means if the articles of the company do allow, they can cancel out or forfeit your shares. That's what you mean by forfeiture of shares. That's what you mean by forfeiture of shares. Forfeiture of shares. Conversion of a share certificate into what? A share warrant. Conversion of a share certificate into what? A share warrant. You know, when you buy the shares of the company, Gloria, you'll likely be given what? A share certificate. You'll be given a share certificate. Gloria, you'll be given a share certificate. This one will likely be able to authenticate or indicate, indeed, Gloria, you are a valid shareholder, you are a valid member of the company. But if it happens under that share certificate, there's a provision. You can convert it into a negotiable instrument we refer to as a share warrant. If there's a provision that in this case you can convert that share certificate into what we refer to as what? A share warrant. A share warrant is like in this case what? A negotiable instrument. You can be able to transfer to another party. Then eventually once he presents to the company, he'll take over the shares. It's like a check. You know, in this case, when Gloria, you draw a check, you'll give it to what? Benedict. When the Benedict presents to the bank, eventually the money in your account will be drawn and it goes to what? To Benedict. Same case, this one is like what? A negotiable instrument. In this case, you can convert what you've been given as a share certificate. You prepare this share warrant, you give it to what? Benedict. Benedict just appears with it in the company. And the company starts the process of having to do what? Transfer the shares into her name. Eventually, you will lose membership, Gloria, because now you can see you had the shares through the share certificate. But now you've drawn a share warrant. You've told Benedict, go to the company, present it there. When you present it there as Benedict, they will start the process of transferring these shares into your name, Benedict. Eventually, Gloria will lose membership of the company. A share warrant is like a negotiable instrument. Is an instrument upon which one can actually be drawn, or in this case, you can actually be able to draw the name of someone, then eventually he presents to the company and the shares are transferred into his or her name. We call it what? a share warrant. So when you convert your share certificate to a share warrant, you are on the route of losing your membership. You are on the route of losing your membership. So because eventually once it is effected, then you lose your shares and you lose membership of the company. You lose your shares and you lose membership of the company. Those happens to be part of the ways as to how one can eventually lose membership of the company, we can have a break. Let's have a break. Then when we come back, we can continue. A break of 5 minutes. A break of 5 minutes. Yes, welcome back. So confirm there whether we can proceed. Confirm there whether we can proceed. I can see you are saying yes, 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 yes. I can see you are saying yes, yes, yes. Not even a single person is having to say no. Not even a single person is having to say no. Even Faith is saying yes. Wow, 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 wow. Wow, wow, we don't have an option. Now that you are the boss, we have to continue. Now that you are the boss, we don't have an option. But you have to do what we have to continue. So let me see whether we can be able to look at a few questions here before proceed on. So let me just see whether we can be able to have a look at a few questions here before we end up having to proceed, because what we've already been able to cover is very common in the exam. So let me show you an example of how they have tested in the past papers. Because what you're trying to say here, see your story at Japa. These things can just appear in your exam. So don't start having to say it is Greek. I've never heard about this. Teacher kugusia hii hata sijui ni gani. So they're in the past papers. So let me show you the examples of how they have actually been able to test just in a few. Just in a few. Just in a few. So of course there's this one here. It was tested in April 2025. We haven't looked at it, but let me just show you so that the rights of a member of a company, rights of a member of a company, rights of a member of a company. You can see this one here, then this one here. It is question number 2B. We're just going to look at it. In fact, it's part of what you'll be able to finalize in this topic. You can see, discuss 6 rights of members of a registered company. Discuss 6 rights of members of a registered company. Right to vote, right to receive dividends, right to get notices of meetings, right to attend meetings, right to a copy of the financial statements. We're going to look at them in a few. So I think that was the one they tested there regarding membership. There's no any other question regarding membership. Regarding membership, there isn't. But now let me show you another one where they ended up having to test on how to become a member. So that was in April. So, but let me show you the one they tested on membership. There are a few questions here regarding membership. Membership. That is topic 3. Regarding membership. So you can look at this question here. April 2022, question number 1A. Highlight 6 ways in which a person might become a member of the company. So we just looked at it a while ago by allotment, subscribing to the memorandum, agreeing to become a member, and your name is eventually entered on the register, agreeing to take up qualification shares, like Lena, who we said eventually very soon, she's going to be a director at Safaricom. She'll be called upon to take up some shares through transfer, where we have 2 parties, transferor, transferee, transmission in case of death, insanity, or bankruptcy, or lunacy. Lunacy is the same as insanity. Lunacy is the same as insanity through the doctrine of estoppel. So that one, also that one of cessation, they really like it. I don't know that I'll be able to see one here, because these others, we haven't covered them. So let's not start confusing ourselves with things we haven't covered. We haven't covered derivative claim, not yet. So that's just some of the results how they can end up having to test this particular topic here. We are having to call what membership. We have to call membership. These others we haven't covered. You can see this one that was repeated here. In May 2018, describe 3 ways through which a person might become a member of the company. They really like that question. They really like that. How to become a member. How to become a member. How to become a member. But just before we took the break, I can see some of our friends had asked some pertinent questions here. So let me see whether I can be able to get them. When one agrees to become a member, is there a contract signed? So there's, for example, in a private company, then there's what we call a share transfer form. This share transfer form, you'll get it from the register of companies. And you can be able to get it from the register of companies. Then you likely fill it out. Then it is normally certified by a company secretary. Then you submit. So the 2 parties transferring shares amongst themselves, they'll end up having to sign that share transfer form. Then once they have already been able to agree, then the company secretary can be able to certify it. Then they submit to the register of companies, and eventually through that kind of an agreement, eventually the person becomes the member of the company. So we learn about the share transfer in the next topic, which is actually topic number 4, as to how shares are transferred in a company. So there's one of our friends here who was asking a question here. Let me see whether I can be able to get this question. It was about what? Does that mean you don't necessarily, that is many, does that mean you don't necessarily pay for entire shares you subscribe for on the commencement, or it depends with the memorandum of association? So I think I was making a reference to what we call allotment of shares. That's what I was having to say, that that is a concept you learned about in financial accounting. Under allotment of shares, there are different ways a company can end up having to allot shares. So when allotting shares, it means they have offered shares. They have offered shares to the members of the public, like what this Kenya pipeline has done. They can say each and every share is having to go for 9 shillings, but they say on allotment, you should pay like maybe 6 shillings. Then when they make the first call, you make a payment of another shilling. Second call, payment of another shilling. Then third, final call, payment of, then in full, you would have been able to pay 9 shillings. So mainly it happens on allotment of shares. It happens on allotment of shares. That is an approach the company can be able to take when they're having to allot the shares. It happens on allotment of the shares. Then there was one of our friends in this case was having to ask, on mortgaging of shares, at what particular point in time does the shareholder lose the shares? Under mortgaging of shares, hope I can be able to get the question very clearly. That on mortgaging of shares, does the shareholder lose the shares immediately, or maybe later on after he has already been able to default? So when we go to the next topic, which is actually topic number 4, we will learn about mortgaging of shares, where I'll end up having to teach you and inform you there are 2 modes of mortgaging of shares. There's what we call equitable mortgaging, and there's what we call legal mortgaging. Under legal mortgaging, indeed, it actually happens immediately when the lending of the money has occurred. Under equitable mortgaging, indeed, it ends up having to happen when you have defaulted. So it depends. The lender can be able to decide immediately on the lending of the money. The shares are transferred into what? Their name. Alternatively, they can be able to agree that when you have defaulted is when they take the step. Of course, when you get there, we'll get to learn what are the benefits if you go for legal mortgaging and what are the disadvantages when you go for equitable. So we get to look at that, but that is what it depends. It can be immediately or it can be maybe later on. So there are 2 modes of mortgaging, legal and equitable mortgaging. So we learn more about them in our next topic, which is actually topic number 4. Number 4. So it depends. Yes, I can see Mary Luck says got it. Mary Luck says got it. I can see Mary Jane is having to ask, when one agrees to become a member, is there a contract? This one I think I've explained. I've said there's a share transfer form upon which once you sign it, it's like you've entered into an agreement. That share transfer form has 2 parties to sign, the transferor and the transferee. When they sign it up, is the basis upon which the agreement or contract of transfer has been entered into. So that share transfer form is the basis upon which the agreement or contract of transfer has actually been entered into. Yeah, so I think I've been able to answer those questions. You know, many luck will just end up having to say, 𝐂𝐶𝐴𝐻, and I ignore my questions. Ananiboaje, 𝐂𝐶𝐴𝐻. Hata aliona nini yangu, 𝐂𝐶𝐴𝐻 ananiboaje, but I think I've been able to answer that one. So let's move on. So in this case, you can actually move on and look at some of the membership rights. I think in this case, they're actually listed in your notes. You can be able to see them. So there are so many membership rights that you'll be able to enjoy eventually once you become a member of the company. There are a number of membership rights that you'll be able to enjoy eventually once you become a member of the company. And of course, you can be able to see in that question that I've just been able to show you in the past papers, they were asking, what are the membership rights? And in fact, if you check your notes, I've highlighted that area of membership rights. Meaning what? What does it mean? It is a danger, Musumeno, that one. You have to really to be very keen when you're having to go through the notes. Don't ignore it and say this membership rights is nothing. So you have to be very keen with regard to what membership rights, because you can see it can easily be tested. And it has not only been tested in that sitting that I've just showed you. In the past papers, it is in there almost 4 times. It is one of the commonest areas they are likely to test you on, the membership rights. So of course now, eventually when you become a member of the company, there are certain rights you'll end up having to enjoy. You'll likely end up having to enjoy. If you look at your note, in this case, you're having to say, right to be sent a proposed written what? Resolution. Right to be sent a proposed written what? Resolution. So when you talk about a proposed written resolution, right to be sent a proposed, right to be sent a proposed written resolution. What is actually a resolution? So a resolution is actually what has actually been agreed upon at a company meeting. So if in this case, it is a resolution that in this case has been proposed, it means it's one that they're actually going to approve at a company meeting. Maybe the company has convened a meeting. Part of what they have actually been able to agree, they're going to change the articles. So they have already proposed the articles they are going to change. They have sent you in advance when they are sending out the notice for the meeting. They have informed you they are proposing to change the articles of the company here and there. Like what you're having to talk about in our last class, which should actually be in conformity with the requirements of the statutes. So if that is the case, it means you'll be entitled as a member because you have to go there and actually in this case discuss and actually agree, yes, we can be able to vary like this and this. So if there's actually any proposed change of resolution or a proposed written resolution that has to be approved at a company meeting, you'll have to be sent. You have a right. You are actually entitled to get a copy of it before you can converge at that meeting as what? One of the members of the company. You can see the other right to require circulation of written what? Resolution. So you can in this case call upon if there's actually any proposed or written resolution that hasn't actually been circulated. You can actually call upon the directors or maybe the company secretary or that person having to convene the meeting to send out that resolution to each and every member of the company. Then the right to require directors to call a general meeting. You have that right. You can write to the directors. Tell them there's a matter of urgency in this company of ours. Me as a member, I feel like we should be able to converge a meeting. And of course, later on, when we'll be looking at topic number 7, we look at the threshold upon which members will be entitled to call for a meeting. We'll say those who are having to hold more than a tenth of the issued shares of the company are entitled to write to directors to call upon them to converge what? A meeting or to call upon for a meeting in the company. If they refuse, there's another option. They can go to the court and actually call upon the court to call for what? A meeting in the company because the directors might refuse. So, but now in this case, you're having to say, you as a member, you're actually entitled to be able to call upon directors for a general meeting. A general meeting is a meeting of the members of the company. Of course, you haven't gotten there, but we'll learn more about meetings of companies in topic number 7. Then you can see the right to receive notices of general meetings. A notice convening any meeting in the company, it means you are entitled to it as a member of the company. So you have to be sent a copy of this notice convening what? The meeting. So these notices are part of what they can be able to attach with what? Proposed written resolutions. On this notice, they can be able to attach what? Proposed written resolutions to be approved at that meeting. That notice is having to do what? Call for. The right to require circulation of a statement. Or this like in this case, what? The chairman's statement. You know, in this case, the chairman of the board. The chairman of the board. Chairman of the board. Bazoo or my director in the company, he can actually make what? A statement. Especially they like having to make statements when they're having to make their presentations at the AGM or the annual general meeting. And therefore, you as a member of the company, you can actually call upon the chairman of the board to, in this case, pass any kind of what? Relevant statement or send any relevant what? Statement. The right to appoint a proxy to act on your behalf in meetings. Who is a proxy? A proxy is a person who can end up having to represent you at a company meeting whenever you're not actually able to attend. What happens, we're having to say, part of the accompaniments of that notice that is convening a meeting at a company, they can attach what we call a proxy form. That proxy form, you can be able to fill it out. Now that you are the member of the company, you're not able to attend, you can appoint someone to represent you at a company meeting. That person, we refer to him as a proxy. You are entitled to these rights as a member of the company. As a member of the company. Of course, still you'll likely be able to learn more about it in topic 7 under meetings. But just take note, when you talk about a proxy, he's a person who can be able to represent you at a company meeting. What happens when the company is having to convene the meeting, when they are sending out the notice? they are supposed to attach or accompany that notice with a proxy form. That proxy form, you can be able to fill it out and send it back to the company before the meeting actually ends up having to do it, to happen, ends up having to happen. And therefore, that's what they mean by what? Proxy. The right to be sent a copy of the company's annual financial statements once they have actually been approved by the auditor. That is, the auditor has already been able to give out his report, his opinion. So the audited financial statements, before we converge at the AGM and approve these annual financial statements, you as a member of the company, you are entitled to get a copy of these annual approved or audited what? Financial statements. So that in this case, when you come at that AGM, you'll likely be asking directors. I've just seen in this case, you've awarded yourself a lot of bonuses and you're just idling there in the offices. What are you doing? Which kind of nonsense? You have that right to question those kind of things in what? In the AGM, and therefore you'll be entitled to get what? A copy of the annual financial what? Statements. So that's the right you have. Then, if the company is a public company, the right to require the circulation of a resolution for the annual general meeting of what? Of the company. So if this is just the same as like this other point here. So an AGM is a special kind of a meeting that is normally held once each and every year. Once each and every year. It is normally held majorly within 6 months after the end of what? After the end of the financial year. So that's why you see most of the companies, they do their AGMs between January and March, April to June there. So within a period of 6 months after the end of the financial year is because they want to come and actually approve the annual financial statements. And therefore, if there's actually any kind of resolution to be approved at this kind of AGM, then you as a member, you have a right to call upon for the circulation of that kind of what? Proposed resolution. Right to receive dividends. This is the most highest level of expectation of any shareholder that have acquired shares at KPC. But are they going to pay me dividends at the end of the financial year? If it happens they have made a profit and they have actually declared the dividends, then I'm entitled to get a share or a portion of these what? Dividends. So when you talk about dividends, is what you enjoy from the company out of the profits which have actually been realized by the company. So once the company has been able to do their mathematics and actually computations and their financial statements, they'll have what? The profit after tax. Profit after tax. Out of the profit after tax, they can be able to transfer some to reserves. Then part of them also, they can end up having to pay out as what? As dividends. As dividends. So you are entitled once they have declared. So dividends is normally proposed by directors. Then eventually approved by members or shareholders at an AGM. Once it has been approved, then you have the right to get a portion of these what? Dividends. That is part of the other right you can be able to enjoy as a member of the company. The right to vote at general meetings of the company. So we'll see, we talk about resolutions here, is normally through what? Voting. So we'll say voting, it can either be by show of hands, or it can actually be by having to do what? Cast ballots. Cast ballots at a general meeting of the company. And therefore you will decide or approve a resolution depending upon the threshold required. Like we say when you talk about change of name. Benedict, do you remember change of name? Change of name. We say for change of name, you need what? Special resolution. You remember change of name? You know, in this case, Benedict might have actually forgotten. Change of name. We say change of name, you require a special resolution. A special resolution. These are kind of resolutions that requires what? A supermajority, more than 75% of the voting rights. More than 75% of the voting rights to approve. More than 75% of the voting rights to approve. One thing you have to take note of, listen to this very keenly. One thing you have to take note of, listen to this very keenly, learner. In a company, the voting rights are normally dependent upon the number of shares you hold in the company. So it is not what? 1 man, 1 shilling. Is it 1 man? Remember that statement. 1 man, 1. It is not 1 man, 1 vote. It is normally dependent upon the number of shares you hold in the company. What I'm having to mean here, if it happens, our friend Gloria is having to hold 60% of the company we are in, all of us, around 150, all of us. And Gloria is having to hold 60% of the shares in that company. Gloria has a bigger say than all the other 149 of us. Voting in a company is normally dependent upon the number of shares you hold in the company. It's not one man, one vote. It's dependent upon the number of shares you hold in the company. The more shares you have in the company, the more voting rights you have. And therefore, when I talk about voting rights here, cumulatively, those who have actually been able to vote, they're having to hold more than 75% of the shares in the company. There might be 2 out of the 150. So long as they have met this threshold, then they have actually been able to do what? Approve what? A special resolution. So when you talk about voting rights in a company, it's not one man, one vote. It is one man, number of shares. One man, number of shares. So if it happens I have more shares than you, then I have more voting rights than you. If I have 100 shares and you have 2, then I have more voting rights than you, because you can see I have more shares. So the percentage in terms of voting rights will be more for me than yours. It is dependent upon the number of shares you hold in the company. So it means if Gloria has 60%, atatukalia mbaya. In this case, we won't actually be breathing. So when she shouts, we have to, in this case, bow. When she says run, we have to run, because she's the one in this case who will be able to decide upon almost everything. Because most of the matters in this case we approve by what? Ordinary or what? Special. Ordinary just requires more than 50%. So it means only single-handedly Gloria can be able to pass an ordinary resolution, like approving what? The annual dividends. She can be able to approve it, because she's holding 60% of the shares in the company. 60% of the shares what? In the company. So you can see in this case you're having to say it is dependent upon the number of shares. So one of the rights you have in the company is the right to vote at general meetings of what? Of the company. Then the last one, right to petition, to call upon for the life of the company to come to an end. Life to petition or to call upon for the life of the company to come to an end. To petition for liquidation. So that right is actually provided for under the Companies Act, and you can't actually end up having to deny the members of the company. So a member of the company can petition or go to the court and present reasons and claim that this company of ours, it should actually be liquidated. As long as it provides valid reasons, the court can give out an order that the life of the company should end up having to come to an end, or it should be liquidated. So we look at liquidation of companies in topic number 15. Topic number 15, where we say one of the parties who can petition for compulsory liquidation is a member of the company or a creditor of the company. We have other parties also. It can be through a special resolution in the company, so they can decide they're going to liquidate the company. So a member of the company, you are entitled to that right of petitioning or calling upon for the life of the company to come to an end. So long as you provide what? Valid reasons as to why you want the life of the company to come to an end. You want the life of the company to come to an end. You have the life of the company to do what? To come to an end. So that's what will likely end up having to happen as what? The rights. So you have to remember the rights. So don't forget about the rights. It is very common in the exam. Very common. Very common. There's a sitting they ended up having to test on it. Then they called upon students to list 8 rights. To list 8 rights, 8 marks. So I'll be able to show you that sitting. 8 rights. List 8 rights of a member of the company. Then 8 marks. That's why you can see there are so many of them that you can actually be able to talk about. I want us to talk about what the register of members. Register of members. We had already mentioned it briefly. When I was having to introduce, but I want us now we close this class. We finish up this class by looking at the register of what? Members. Register of the members and the contents. Register of members and the contents. So already I've mentioned that the register of members will actually enlist all those who are members of the company. So register of members. And we talk about register of members. Remember these things, the contents. Remember these things about the register. Contents, the location. Location of the register of members. Location of register of members. Then also, there's normally what? Variation. So there can actually be variation or maybe having to adjust the register of members. So variation and actually adjustment of the register of members. Rectification. We call it rectification. So rectification. Rectification of the register. So you must actually be able to know under what circumstances can you actually end up having to rectify. Rectify is to change. Rectify is to change. Rectify is to change. So the register of members, you've already been able to say it enlists all those who are members of what? Of the company. So obviously the contents that will be there will actually comprise of the name of the member, name of the member, name of the member, number of shares held, if he or she has shares, number of shares held. If, for example, is a company limited by shares, number of shares held. Then the dates when one became a member, dates when one became what? A member. Then if it happens, one has ceased to be a member, then also the date of what? Cessation of membership. Date of cessation. Date of cessation of membership will likely also be indicated there. Those are part of the contents of the register of what? Of members. It will have the name. So we can talk about also the address. When you talk about the name, then you obviously have what? The address. Name, address of the member. Name and address of the member. Name and address of the member. It will have the number of shares held by this member. It is a company limited by shares. The dates when this person actually became a member. Then if it happens, the person has ceased to be a member, then the date of cessation. Date of cessation of membership. Date of cessation of membership, meaning he or she is no longer a member of the company, meaning he or she is no longer a member of the company. Then when you talk about location, this register of members of the company will likely be located at the registered office of the company. So there are those locations where it can actually be kept. It can be at the registered office. It can be at the registered office, or it can be at any branch of the company. Any branch of the company. Alternatively, it can be located at the place or maybe location where the person who makes adjustments or who maintains it, the person who maintains it is located. The person who maintains the register is located. This one is actually just alluding to the company secretary. It's just having to allude to the company secretary. So these are the locations where the register can be kept. At the officially recognized registered office of the company, at any branch of the company, if it happens it has a branch, or at the office of the person who maintains the register of the company. Obviously, we are having to allude to what? The company secretary, because that is one of the roles or key roles of a company secretary. So at his office, maybe you would have actually outsourced the functions of a company secretary. So it can actually still actually do what? Be maintained there at his office. So these are the locations where the register can actually be maintained. Then on these matters pertaining to the register of members, so of course the register of members is actually recommended for companies to be able to do what? Maintain it. But now it will be maintained in a different form. It will be maintained in a different form. If it happens, the company has more than 50 members. If the company has more than 50 members, then this register will actually be maintained in a form we call what? Index. An index. We call it an index of members. We call it an index of members. It will be maintained in a form we refer to as what? An index of members. So if the company has more than 50 members, it will be maintained in an index form. So index of members. We call it index of members. Index of members, it will end up having to capture all the particulars pertaining to a register of members. Only that for each and every member, we'll have like a unique identifying card, or maybe particulars on a unique identifying card, which will end up having to capture all these particulars. So we call it an index. So when you go to the index, you'll be finding like what? The card of each and every member separately having been indicated. Then it is not a list now, like a separate identification card that is having to show the particulars of a member. So we call it what? An index of members. So it is a requirement. If it happens that the members of the company are more than 50, then the company will likely be called upon to maintain the register in what we call an index of members, where same particulars will be captured under that index of members. Only that for the index of members, for each and every member in that register, they'll have like a unique identifying card or a unique identifying particulars that are having only to be maintained for that specific member under that card. And what will be captured under that card will likely be what? All these particulars we talked about, what? A register of members. A register of members. That's also what you need to be able to do what? Talk about. So of course you talked about rectification of register of members, but also when you talk about register of members, don't forget about also inspection. Inspection is very important. You remember about it also. Inspection Inspection is very important. You likely remember about it. Inspection, you remember about it. So this register of members will likely be open for inspection. So you can actually, in this case, go to the company and actually call upon them to give you the register of members, because you want to end up having to do what? Inspect. So it can be open for free to the members of the company for inspection. But if it happens, you're not a member of the company, then you'll end up having to be called upon to pay a fee before you can inspect or have a look at the register of members. So with regard to inspection, the register is open for inspection for free to the members of the company at designated what? Maybe number of days in a week, or maybe designated what? Times. Designated times for, in this case, of the members of the company. It is for free. But now if you are, in this case, any other person, you likely end up having to pay a fee, and you can be allowed to inspect it or have a look at what? The register of members. Sometimes there can be closure where they won't allow you to do the inspection. They can close it. There can be closure of the register of members that they don't actually allow any party to end up having to do it, inspect it. This could be due to a number of reasons. Maybe the company wants to hold what? A general meeting, and therefore they're having to utilize this what? Register. Because they want even to know what valid members who have actually been able to attend what? That meeting. So it won't be open because they want to end up having to do what? Utilize it. So in order to hold, for example, an AGM, or they want, in this case, to utilize it to declare dividends, or they want to utilize it to make a call for those who have not actually been able to do what? Make a payment on any outstanding amount on their shares. So they likely close this register. It won't actually be open for inspection. So if they want to pay dividends, they want to declare dividends, they want to utilize it for holding of an AGM, they want to make a call on any outstanding amount of the shares, and therefore they're using this register for that purpose. It can actually be closed. There'll be the closure of the register. And therefore they won't allow for inspection. They won't allow it for inspection. They can actually close it. And of course, before they close it, they can give out a notice or send out a notice that there is no any further inspection of the register of members of the company for this number of days. Then eventually after that, they can actually be able to allow any person to be able to inspect the register of members. Then this register of members, of course, it can actually be rectified. It can be rectified. So by rectifying, it's like having to add people and remove people. So just as we've been able to say, some are losing memberships, some have actually been put there by mistake. So it can be rectified. It can actually be rectified due to a number of reasons. Maybe it could be that a party or a person has been inadvertently been added to that register by mistake, and therefore they have to remove what? His name. Or it could be the opposite has occurred. A person's name has actually been omitted by mistake in the register of members. So they are called upon for the rectification of the register of what? Of members by the company secretary. So the company secretary will likely end up having to proceed and rectify any matters that in this case are required to be rectified in the register, whether it is actually addition or removal of members due to a number of reasons. Maybe their name is having to appear by mistake, or they are no longer having to be members or shareholders of the company. The register of members can be rectified. The most commonly tested area in this area of register of members, it is the contents. All the other things I've talked about, they rarely test them, like closure, but you have to be aware of them. Or they can actually end up having to call upon you to indicate what are the provisions regarding the register of members as per the Companies Act. So when they say that, talk about all this, the contents, the location, what I've said, the rectification, what I've said, and the inspection. What are the provisions with regard to the register of members under the Companies Act? So you can talk about the contents as per the Companies Act include the location of the register is actually at the branch, at the registered office, or at the office, the person upon which ends up having to maintain that register. Then we talk about the same register of members. If the company has more than 50 members, then it will be called upon to maintain an index of members. But what they are likely in this case to test very commonly is normally this one, the contents. It's normally the contents. They'll ask about the contents of the register of members. The contents of the register of members. So don't forget about the contents of the register of members. I think we can end there. So we can end there for today. So we'll wind up with these other things later on about majority rule, about derivative action, about representative action. So we look at them in our next lesson. So let's see what people are asking here. Right to alter the memorandum and the articles in accordance with what? With the law. Right to alter the memorandum and the articles in accordance with what? With the law. That is the right of the members. What? Right of the members. Right of the members. What of the number of shares? I don't know what Mary Jane is talking about. What of the number of shares? We've already been able to indicate. So the number of shares held. We talked about it. Number of shares held by the member. So if it happens, it's a company limited by what? By shares. It is a company limited by shares. Any other question? Any other question before we proceed? Before we close? Any other question? So I think there is a does valid surrender has a process? Does valid surrender has a process? So because if you're having to validly surrender, it just means you have to do what? Notify the company. You can just notify the company. It can be in writing. It can actually be in writing that you are validly having to surrender your shares. Or maybe you are surrendering the shares to another party. You are surrendering if you are surrendering the shares to another party, it means you likely write the consent to the company. Then at the same time, you'll have to fill out the share transfer form to agree that you've transferred or surrendered the shares to another party. Without that party having to pay any price or consideration, you surrender to that party. And therefore, you fill out a share transfer form, that party signs, then of course, you surrender the shares to that party. So you can write a consent, and then if you're transferring the shares to another party, you fill out a share transfer form, upon which now the company will facilitate the transfer to the name of that person you're having to surrender to. Any other question? Any other question? If there isn't, so I think let's end there. So let's say hooray to this class. I wish all of you a good night. So we have a revision class. When is it? Is it Friday? We do have a revision class. Is it Friday or when is it? You had agreed when? Is it Friday or Thursday? It's one of the 2 days. It's one of the 2 days. Who can apply for rectification? It can be the member of the company. It can be the member of the company. So on Friday 1, so the 1:15. Friday 1:15, there will be a revision session for 30 minutes. So those who won't be able to attend, you'll get that particular class on the LMS. So you'll get that particular class on the LMS. Thank you for today's class. I'm starting to enjoy. So I told you Melvin, you stick in. So you know you are almost having to exit the class the other day. I told you just stick in. So zitaanza kuingiana tu. If you start having to exit the class because you are floating, then you won't be able to get it. You'll come back again after 2 weeks, you are still floating. You just stick in. So they'll start just having to flow like that. They'll just start having to flow like that. Yeah, so I think that's it. So you can have a good night. So let's catch up on Friday, 1:15 p.m. Thank you so much and have a good night.